Well, welcome all to the Asia Law Weekly Speaker Series. I'm Jose Alvarez, the Faculty Director of USALI, and thank you for joining us. Today our talk is entitled China and Authoritarian International Law with Professor Tom Ginsburg of the University of Chicago. So a little bit about our speaker today. He's extremely distinguished. That is, he is Leo Spitz, a professor of international law and a professor of political science at the University of Chicago Law School. He focuses on comparative and international law from an interdisciplinary perspective. He is the author or editor of 25 books, an astounding number for somebody who doesn't look 90 years old, at least from what I can tell. Among the books, especially related, I think, to today's topic, is a book he edited back in 2008 called Rule by Law: The Politics of Courts in Authoritarian Regimes, and another edited book, Constitutions in Authoritarian Regimes, from 2014. But his most recent book is How to Save a Constitutional Democracy, co-written with Aziz Hug, and his earlier books include Judicial Review and New Democracies, which won the C. Herman Pritchett Award from the American Political Science Association. He is a member of a number of editorial boards, including the American Journal of International Law, which published the article that I think inspires today's talk, called Authoritarian International Law, in the American Journal of International Law's April 2020 issue. And that article is available for free if you go to the link at the American Journal of International Law, which is under the Cambridge Core publishing website. That article has been all over the place. That is, Professor Ginsburg has been, and that includes a featured podcast in the American Society of International Law as of May 1st, 2020. He presented the article at Pluricourts, that some of you may know, a leading NGO or research center, I should say, on the topic of international courts, and he spoke there in June of 2019. He spoke at Frank Upham's and my colloquium, and he was the first speaker in that colloquium just a few weeks ago here at NYU, and he has given a talk on this. Last I checked, maybe there's more that I have missed at the ABA International section. So the book, the article, and actually the book, I think, is going to get even more attention once it's published. What you should also know about Professor Ginsburg is, of course, he's visited a number of universities in the region, including in the region, Seoul National University, for instance, a number of visits to the University of Tokyo, but he's also been someone who knows the area from the practitioner or the policy-making side. He's been involved in constitutional and legal reform projects in over 20 countries, from Afghanistan to Vietnam. So with that, I turn it over to Professor Ginsburg.
Great, thank you so much, Jose, and thanks to everyone for joining me this morning, relatively early, to talk about this work I've been doing on authoritarian international law. It sort of flows directly out of my long-standing concern with both democracy and dictatorship. And I just want to start by putting a few preliminaries out there on the table. So I define democracy in a specific way, and this comes out of my co-authored work with Aziz Haq, as being, obviously elections. You need elections where the loser turns over power to a winner with a real chance of turnover. But as lawyers, I think elections is not enough, right? Because we know that to really have elections that are functional, you need certain core rights, like rights to vote, rights to freedom of speech and association. So we'd include those in our definition of democracy. And the third thing that we include, which is not often included but ought to be, is something we call the bureaucratic rule of law. That is, you need a bureaucracy that sort of follows the direction of changing political leaders in a neutral way, according to law, most obviously to count the votes, but also to incentivize political turnover. If you think about it, if a new incoming administration could appoint 2 million civil servants in the United States, well, that would probably end democracy because the stakes would be too high to ever give up power. So I want to get that out on the table. Now, classically, international law is neutral as between regime types, right? That there's a plurality of different kinds of political systems in the world, and international law is designed to facilitate exchange among those without imposing a particular regime type on any particular society. And the UN Charter has certainly language which indicates that: non-interference in internal affairs, the domestic jurisdiction, self-determination of governments, etc. Now, that being said, in the 1990s, we saw a real movement among, I guess you'd call them liberal international lawyers, to push for a particular view that said that democracy itself was a right. Actually, an NYU professor, Thomas Frank, famously wrote this.
In this very office that I'm sitting in, he wrote that.
Oh, really? You're sitting in his office. I will note that Professor Alvarez was one of the early critics of that approach, actually, I think, if I remember. But certainly that the idea that democracy was itself a right, which, of course, if you think about it, would mean that non-democratic members of the international community would become sort of illegitimate. So and you know, that decade, of course, saw, and I think culminated, one might say, in liberal overreach, you know, ultimately with the Iraq War, the idea that we could actually go to wage war on a country to turn it into a democracy and such. So that was an idea that was out there. And there certainly is some evidence that international law contains kind of pro-democratic, you know, purposes. But at the same time, you know, I think the classic view is kind of what we call Westphalian. Now, what I'm documenting here is the rise of not pro-democratic international law, but pro-authoritarian international law. And I ground that, I first look at, you know, who has contributed more to the formation of international law as we know it. And there are sound reasons to think that democracies will have a particular affinity with international law. And that's because, of course, in a democracy, you know, the government changes, but the regime stays the same, right? That, you know, a democracy depends actually on government stepping down and turning over power peacefully, which means, of course, that those governments have an incentive to find ways to extend their policies and create public goods that will outlast their own political life. It's the nature of democracy, and international is one such mechanism. Now, if you think about a dictatorship, actually the complete opposite probably applies. For a dictatorship, the time horizon of the government and the regime are the same, right? That is, you know, a dictator, let's say a military dictator, is not really looking beyond his or her own political lifetime. Even something like the Chinese Communist Party, which is pretty institutionalized dictatorship, you know, doesn't imagine a China without the Chinese Communist Party, and so is really focused on things which are going to redound to the benefit of the current government, and hopes to extend that government's lifetime as long as possible. That's a fundamental difference between democracy and dictatorship, and that might create different attitudes towards international law. Certainly, less desire for publicity, for the surprises which can come if you send disputes to the third-party dispute resolution. And even, you know, locking in deep commitments in the form of treaties. And it turns out, and my article documents this in a book project, which will be out next year, doesn't in much more detail. It turns out that democracies really dominate the creation of international law in terms of, you know, much more higher propensity to make treaties, actually much higher propensity to bring disputes to third-party dispute resolvers like the International Court of Justice or the Law of the Sea Tribunal. And interestingly, a much greater role in creating the kind of bureaucratic international law at the international organizations, which Professor Alvarez has written upon. I have some evidence that, for example, at the meetings of these organizations like the International Law Commission or the UNCITRAL, that democracies really dominate those representative democratic countries. So it's pretty interesting that international law, even though it may not be pro-democratic, is largely produced by democracies. Now, what I argue is that this is now changing. And what we're seeing, and it sort of builds on a finding from work in national constitutions, and actually a long literature now that we have for at least a decade on authoritarian regimes. What scholars of authoritarianism focus on is that today's authoritarians, if you think about it, look a lot like democracies in terms of constitutional structure, in terms of having elections, in terms of a nominally free media, in terms of even things which look like civil society. But those sort of formal institutions function in a very different way in authoritarian regimes than they do in democracies. In an authoritarian regime, nominally independent courts are there not to constrain the core interests of the regime, but to do things like discipline lower level agents, for example, or facilitate, contract dispute resolution so that the economy grows. But they never constrain the actual core of the regime. And so, it's what we call rule by law, not rule of law. Still law nonetheless, but with a very different function. And in general, I think what we see with all kinds of institutions is that democracies innovate, and then authoritarians mimic those institutions and then repurpose them for a very different purpose. And this is particularly evident in our era of hybrid regimes, of democratic erosion, so that the most common way for a democracy to end these days is not like some sudden collapse or some coup d'etat, but rather a slow process of takeover of nominally neutral institutions by a particular leader or a particular faction, a particular party. And we've seen in many countries, it's actually a real concern here in the United States. All of this means that we are now seeing demand for what I'm calling authoritarian international law, which I define as legal behavior designed to extend the survival and reach of the authoritarian regime across space and time. And it's an interesting thing. It takes in a formal sense, a lot of the rhetoric sounds in sort of classic Westphalian principles of international law: non-interference, sovereignty, mutual respect. But in practice, we are now seeing a much more aggressive stance. The focus tends to be on internal security rather than external security. And delegation to international organizations is pretty low. Certainly third-party dispute resolution is really low, but we are actually, I think, I would argue, seeing much more active use of international legal mechanisms. So I go through the various history, starting with the Warsaw Pact and various other Cold War era international legal institutions. And I place a lot of emphasis actually on the Shanghai Cooperation Organization, which is a Chinese innovation, of course, and one in which scholars didn't really think much of. They tended to say, it's just this formal organization, really didn't understand what it was doing. But in form, it looks very different than a Western international organization. It doesn't involve deep cooperation. It's much more of like a hub and spokes kind of network, or one in which the leaders get together and cooperate without a lot of institutionalization. But it has, in recent years, begun to be a real innovator in international law. So it's created these regional three evils, as they're called, terrorism, separatism, and extremism, which you now see being used in the rhetoric. So the Hong Kong protesters are called extremists. The new national security law of Beijing for the Hong Kong Special Administrative Region, uses these ideas and criminalizes their behavior, their deployment anywhere in the world. So we're seeing extraterritorial jurisdiction being used in that case by the Chinese government for very political purposes, basically for internal security. So naming new crimes, if you will. Terrorism, of course, already was an international crime widely accepted, but separatism is not. And indeed, making a crime out of separatist discourse might arguably go against the general principle of self-determination, right? The law of self-determination in international law, which says, arguably, that in conditions of severe oppression, there might be a right to secede from an existing state, like South Sudan or Kosovo. Of course, that door would be shut if separatist discourse is itself totally criminalized. So we also see in the Shanghai Cooperation Organization a lot of mutual extradition. I also argue that Asean, which one would think of as kind of a general international organization, we've seen a rise as more authoritarian countries a rise in ASEAN as ASEAN becomes more authoritarian in its member states. A lot more mutual extradition of each other's dissidents, also dissidents being extradited from countries to China. Even Turkey, which is arguably an authoritarian country now, a long-standing defender of the Uyghurs, co-ethnics in Xinjiang, is extraditing them now to China. And another, I suppose, arena in which we see authoritarian international law is the whole UN system, in which China, of course, has been playing a much more active role even than the United States, which now is sort of a rogue regime, I suppose, in that regard. I call the United States a revisionist hegemon. So, we set up this system and now we don't like it, and so we're leaving it. And that's particularly apparent in the UN, which means that Chinese concepts and ideas and institutions are able to institutionalize themselves within the United Nations. And it has very real effects for human rights and dissidents, for sure. So, for example, a proposal to condemn the activities going on in Xinjiang received not a single vote of support from any member of the Organization of the Islamic Conference. And in fact, many democracies did not vote for that. Smaller democracies, which are basically, subject to Chinese, they see no reason to go against a rising hegemon when there's no democracy on the other side leaning on them to vote with democracy. So that gets a bit to the normative implications of the paper. Two other things I'll mention. We see interesting authoritarian deployment of international organizations. This isn't directly international law, but we see a mimicry of things like election monitoring. So, one of the things in the 1990s, election monitoring by democracies to ensure that other democracies, democratic elections, are going to be held in a free and fair way. We could use little next month in the United States, probably. But what we've seen is authoritarian international organizations, including the Shanghai Cooperation Organization and the Commonwealth of Independent States, set up their own election monitors that then go out and bless elections, which are often stolen, right? So there's a kind of mudding of the waters and the institutions by which democracies were supporting each other. A third thing I'll mention is cyber. And this is one where there's a UN effort now afoot to have a new treaty on cyberspace. The current treaty is one that's from the Council of Europe and has many members outside the Council of Europe. This sort of protects core interests in a free and open internet. And the UN effort, sponsored heavily by China, is a very different internet. And so that's one where I think pretty important stakes in terms of future possibilities for democracies. We're seeing some of this space be constrained. So this is the rise of authoritarian international law. What's to be done? I mean, I think that's a big separate story, but clearly at a minimum, democracies should recognize that we have common interests in democratic government, and international law can be used not to expand that sphere. We shouldn't go into, to think, we should not believe that every country is naturally a democracy and thus international law be used as the aggressive spread and become inherently pro-democratic in its criteria. But we can use international law to defend existing democracies from backsliding. And we have some interesting examples at the regional level. Actually, most effectively, in my view, in Africa, not so much in Europe or arguably Latin America. So that's really important, defending democratic institutions collectively. And I think also I've been thinking about other international legal regimes which aren't directly about democracy, but might have important collateral effects on democracy's abilities to retain their status, things like investment law. I want to say one last word because I promised I wouldn't talk too long, but it has to do with the Belt and Road Initiative, which of course everyone is familiar with, the massive infrastructure program by which China is this map basically going all the way from Spain to Indonesia and Australia of countries with which it will cooperate in recycling its infrastructure capacity and in extending credit, and actually really, I view it as creating a kind of strategic depth in the economic sphere, giving China a good deal of flexibility in terms of where production will happen, and certainly has a diplomatic and military component as well. Now, I think the U.S. government's view is this is, something that must be stopped. It's a great overreach, and countries will be trapped into debt cycles and things like this. And I have a more ambivalent or benevolent view even of the BRI. I don't think it is designed in an old Cold War kind of way to extend the Chinese model of government, whatever that would mean. I mean, China's record is of tolerating democracies. It really does sort of take the rhetoric of international law seriously, in the sense that, hey, you can be a democracy dictatorship, fine, just don't touch our core interests, in which case we will be, we will punish you and you will feel the pain. So Mongolia, a country I've spent a lot of time, democracy, right, between China and Russia, fine, China doesn't mess with its status. So I don't think the BRI is going to lead as a matter of policy to the undermining of democracy intentionally. But there certainly is one plausible story where it would have the unintended consequence of doing so, because of course China will need stable governments with which it can cooperate. And someone like the Rajapaksas in Sri Lanka or something might be able to provide that while shrinking their own democratic space. So we're in for a rough ride, and international law is going to be part of it. And I think the minimum we can do is to begin to talk about it and think about these different ways in which international law can both facilitate and retard democracy in the 21st century. And with that, I'll stop. I said I wouldn't talk too long, so look forward to the discussion.
So my role is also to encourage folks to put down their questions in the chat box. So I will try to tee up some of those questions. But one is about the binary, right? So authoritarianism versus democracies. And we are talking in an institute that is all about East Asia. And in that region, it's not just China. We're talking about South Korea, we're talking about Singapore, and we're talking about Japan. And when you talk about ASEAN, you're talking about those countries as well. And I'm not sure ASEAN is the authoritarian organization that you described, I think more accurately perhaps, in the Shanghai Cooperation Council. So I guess first is the binary aspect. Is it really true to say that there is a consistent position on international law, on international organizations, on international economic law, when you're talking about the authoritarians in East Asia? And I would identify Singapore, for instance. So where's the nuance here in this binary?
Yeah, all right. So it is certainly a binary in the sense that, certainly the empirical part, I sort of divide countries into democracies and non-democracies. But obviously the latter category is incredibly diverse with incredibly common interests, right? Even hard dictatorships, range from North Korea to Iran, to Brunei, very different countries, different concerns. So, but I do argue that electoral turnover really does matter. And there certainly are some hybrid countries at the border of the category, as there is for any binary or any categorization. And those might be worth breaking out. But it is also the case that we are seeing, I think, a different form of cooperation among the true authoritarians. If I was to show you a chart of the distribution of international organizations, which I think is in my article, by the modal democracy score of the member, you see a real bimodal distribution. That is, there's a lot of international organizations which are made up entirely of democracies, and a lot of them that are made up entirely of really hard dictatorships. And those things are different, and they do different things. So obviously, as with any categorization, there's subtlety in the middle, but that's not my main concern here, because I think it's it's a refinement that I could go into, but not the core argument. Now, ASEAN is a very interesting case, though. It's true, ASEAN, the countries have sort of gone back and forth from democracy to dictatorship. At this moment, there's only 1.5 real democracies among the 10, which is Indonesia and Malaysia. Singapore is quite a different country, obviously. It's sui generis, I suppose. There aren't many Singapores in the world. Extremely rich, successful non-democracies that nevertheless produce a lot of public goods for their citizens. So I think the main concern of ASEAN when it was formed was basically state building. And that's not an authoritarian or a democratic thing. So I see ASEAN actually as being a much more neutral international organization, pluralist, and pretty successful, but not really, the core of what I'm talking about, which is these kind of new international organizations really designed to extend, certainly with the strong effect of extending authoritarian rule. So maybe that's all I'll say about it. I think it's, it's a legitimate point, but one that's increasingly not going to be that important, I think, as we go forward.
So let me go after that issue. So you describe them as pro-authoritarian regime as opposed to just shielding them from old liberal international law. So, and that point, I think, is less strongly supported in your piece. That is, your piece, those who read it, you stress, and I think you suggested it here, that it's a sword, that it is about promoting authoritarianism just as much as old-fashioned international law was, at least in 1990, from Tom Frank's perspective, all about promoting democracy through supposedly neutral international law. So this is tit for tat. This is now promoting authoritarianism. And you go as far as to suggest that one of the effects is to promote more authoritarian tendencies, even in established democracies. Perhaps not in the United States, strong because it's strong, but in weaker democracies. So could you say a bit more about why it's a sword and not just a shield?
Good, that's a good point. So look, you can be pro-authoritarian and be a shield. I don't think that one has to be one has to wield it as a sword in order to advance the ball. But when I guess what I mean is, you're articulating new concepts on the international plane and changing international law. That is much different than just a purely defensive reaction. Sorry, I'm shutting my noise-making machine here. My computer's going crazy. Sorry. So I think that's, look, it's a fair point. Maybe it's not aggressively pro-authoritarian, but it certainly has that effect. And the example I just gave about Sri Lanka, I think, is a good example. Here you have a government which, I don't know what you want to call it, not really a populist government, but a pretty proto-authoritarian government running for office, backed explicitly and endorsed by China, which had built a port in the home district of the president. And so clearly an alignment. And, it backfired. Turns out he didn't win that election. Now, 4 years later, he's back and talking about instituting a China-sponsored regime. And it's hard to imagine that would be plausible without the actual, support, the economic support of the Chinese government and being able to wield the possibility of cooperation with China through the BRI going forward. So I think it does have a kind of subtle effect, hydraulic effect, on the existence of democracies around the world, which have been, of course, in decline. And maybe one way to think about it is how steep is the slope going to be, and when are we going to be able to reverse that?
So one thing I heard in your discussion of the Silk Road, which basically you have stated you had a separate section on that in your authoritarian international law piece, but it had to drop out, is that when it comes to the Belt and Road Initiative, things are a bit different. That is, you can't exactly, as you just said, identify it as easily as part of this authoritarian move. In fact, it has been endorsed by some 30 memoranda among UN organizations, to the great consternation, of course, of the United States. And I think it leads to a general argument that when it comes to international economic law and international economic regimes, your thesis is a lot weaker. So when I look at trade, I see a China that has thrown itself avidly into binding dispute settlement, become one of the leading litigants in the WTO. Just last week won a case, is not responsible for destroying the appellate body like the United States has endorsed WTO dispute settlement, including the appellate body. And similarly, on the investment side of things, is endorsing now an appellate mechanism as well as a continuation of investor-state dispute settlement. And on the financial side, has created rival institutions like the Asian International Investment Bank, which, yes, serves Chinese interests, but no more so than the voting power of the US meant that the IMF and the World Bank promoted Western corporate interests as well. I don't think people are identifying very plausibly that the Asian Infrastructure Investment Bank, for instance, operates dramatically differently in terms of a variety of issues. So on investment, on trade, on finance, we're not seeing quite what you're describing. That is, there is still a reliance on old-fashioned commitments. There is still a reliance on binding dispute settlements. It's mimicry. It's, as Schaefer and Gao say, repurposing the old institutions, tweaking it a bit, using the old tools of international law to defend Chinese interests, if what we're principally talking about is China, which I think this is really all about. So international economic law, is that an exception, or how do you see exactly that playing into your broader thesis?
So first of all, I mean, these are public goods, which authoritarians would want just as much as democracies. Everyone wants a strong economy. And I should say, the argument is not just about China. I talk about the Gulf Cooperation Council, various other regional institutions and international institutions. But focusing on China is useful because, of course, that's the purpose of this particular meeting. And there, I think we do have to take into account the very specific character of the Chinese approach to international law, and you're going to have Song-Yan Tsai later talking about it. But I think that's critical, that China does have a very particular approach, different maybe from other authoritarians, and that is because it's an aspiring hegemon. And if you are, you certainly gonna, and they've been able effectively to move in and become the chief defender of multilateralism, not just in the economic sphere, but in the Human Rights Committee and things like this, where they're repurposing. That's where you really see the confrontation, right? Not of the economic realm, but in things like the Human Rights Committee, where we're seeing a repurposing of the word of what human rights stands for, human rights with Chinese characteristic. What does democracy mean? Well, there's many ways to do democracy. And China's using all those terms quite well. So I don't see China as a revisionist in any way. I think that they are essentially, trying to overlay the current, structure, slip in, peaceful rise, and then overlay that with some Chinese concepts, and so that we will see indeed some changes, but they won't be evident in the nuts and bolts of ordinary international law. What are the changes? Multilateralism certainly is, continuing. What we see in the BRI is much more of a hub and spokes system than true multilateral institutionalization, right? Whereas, the meetings of the BRI heads of state are sort of like, 60 leaders, each with their own shot with a picture of Xi Jinping. It's not like they're getting together and discussing in a genuine multilateral way how governance is going to work on these things. It's very much a China-centered thing, and that's to be expected. Where I think and argue that there's actually some similarity between the Chinese approach and the American approach is that neither country exercising the power that it does is likely or willing to be constrained by international law when it comes to anything they consider their core interests, right? So we see it in South China Sea, arbitration, just ignore that. The US is like that too. And actually both countries are pretty similar with regard to their approach to, say, the International Criminal Court, right? Or the Human Rights Council. And so there's some odd similarities, which I think don't bode well for 90s style expansion of human rights.
Right, and I totally I totally agree with that. In fact, I suppose that some people would say, look, this is a nice new label for a very old phenomenon. It's called realism. Hans Morgenthau always told us the most powerful state in an international organization is the organization, right? And so what we used to call hegemonic international law, it's just now it's China instead of the US taking the seat, but it's still the old-fashioned hegemonic. It is states pursue their military economic interests. They use international law for that purpose. And that means that we are likely to see reflected some of their national law tendencies onto international law. Why is this different than old-fashioned realism?
Well, first of all, I think China is very realistic in its approach to international relations, no question about that. And it is also the case that democracies, in their cooperation with each other, use international law to do a lot of undemocratic things, right? Support of authoritarian regimes, exporting, creating the financial sanctions regime at the UN with violation of due process norms and things like this. So, in fact, I argue that democracies are especially likely to do those things through international law because they can't do so alone. There certainly were, regime-neutral international law certainly had some non-democratic elements, no question about that. I also use the term hegemonic international law with Chinese characteristics. I think that is what we are going towards and what we are going to see. I don't fully endorse realism, though. I think one bit of evidence for that is the Trump administration's approach to international law, which maybe they think it's realist, but it's not, haven't been very effective. The trade negotiations, all these, trade wars haven't produced much. And it's much more, it's too transactional to be realist. A realist approach to international relations does suggest that there might be need for alliances and balancing and things like this. I think they're just too bumbling. So oddly, China is now maybe the best exemplar of realism and best advocate for its use because it has both a strategy and tactics. But yeah.
And I suppose that leads to, and we're starting to generate some questions in the chat box, and I will certainly start turning to them. But there is a trend in some of the questions to suggest actually the leading proponent of authoritarian international law today is the United States. That is, when you describe the behavior, hostile to human rights, hostile to multilateralism, hostile to international dispute settlement, including in the WTO, and now increasingly in the investment regime, it's the United States, the leading democracy. So why not start there and saying we have a trend towards demise of multilateralism, and it happens to cut across the leading democracy as well as the leading authoritarian state?
That's certainly true, but that's not my concern. So the United States behavior is certainly revisionist, and the interaction of these two hegemons is going to determine the environment or the world order, broadly speaking. But I don't see the United States as being specifically authoritarian. It's just given up on its idea of being pro-democratic. So it's sort of moved to the middle, if you will, of that framework without going, all the way to trying to actively export authoritarianism or anything like that, or even act defensively toward in a regime sense. So but I do think, just looking far to the future, China and the United States, very similar views from some perspectives, but very different approaches to the existing institutions, with the United States being much more revisionist. And whatever happens, and it's impossible, of course, to predict the future with regard to this relationship, there is going to be space for other countries to pursue democratic international law and authoritarian international law. I think that is, there's, China is not trying to impose authoritarianism on all of Africa, for example. And we see not only institutionalized international law, but active demand for democratic participation in countries from Armenia to Zimbabwe. It just, people do want to share in their governance. There's demonstrations going on everywhere about this. And so I think that there's going to continue to be some pressure, even in a China-dominated world, if that's how it turns out, for a role, for voice in governance. And there might be some small space for that, but it's certainly not going to be operating at the level of the UN promoting democracy, or at the BRI.
So let me just, and I'll turn to the questions after one more, which is Japan. So to the extent some of this is about China approaching this through first the nearby region and then expanding to multilateral organizations, what should be Japan's role? It is a leading economy, it's a huge power. It plays a substantial role in the region, including economically through the Trans-Pacific Partnership, for example, the successor to the TPP that the US abandoned. So if you were advising the Japanese government about this, what would you say they ought to do about it?
Right. I think what is true of Japan is also true of ASEAN, which is also, if you add up all the economies, quite a big force. I think that in South Korea as well, which is, they don't want to see some big fight between the United States and China in international economic law, especially. They don't want to be forced to choose. They all know that they're, that their economies are inexorably tied to the Chinese economy, and that's been good for everybody. So, and I think they would, Japan has been a bit of an, not been a major player in terms of international law, our primary topic in terms of staffing, UN agencies and things like this. Whereas China has the depth and the will and has made the strategic decisions since the Jiang Zemin era of really engaging with international law. So I'd like to see Japan do more of that. I think that a Japanese position, which if you talk to friends, people like our friend Hisashi Owada, for example, former judge of the ICJ from Japan, has sort of talked about Japan playing a kind of brokering role between Europe and the United States as kind of, peaceful dispute resolution. Let's help work everything out. It would be good to play that role between China and the United States, but at the end of the day, Japan is a democracy and won't, so I think that would be good for the United States to encourage a greater role for Japan, because they're certainly not going to promote a system of active electoral interference by authoritarian regimes, and not going to promote international legal rules which allow the undermining of democracy. That's my view of it.
So let's start with the questions in the chat box. The first one is about, can you say more about China's involvement in international law enforcement organizations, such as Meng Haowei's being appointed head of Interpol? How did that happen? What was the consequence of that? And if you think he can be removed by the party, what does that say for rule of law and how rule of law countries should be interacting with Interpol?
Yes, that's a great question. So we've certainly seen a concerted effort by China to place its people in UN agencies. I think depends on what you count as a UN specialized agency, but 4 of them, I think there might be 15 or 17, depending how you count. 4 of them are now headed by a Chinese national. 1 is headed by an American. So that's been a concerted effort, and that's a sign of American disengagement as well. And it is true, if those folks are Chinese citizens, they are subject to Chinese law, can be removed at any moment. And this is where the stakes of living in an authoritarian regime should really come home to all of us. Let's not forget, it's easy to talk about nice places like Singapore, say, oh, authoritarianism isn't very bad. But you make a mistake, and Meng, I have no view about Meng's corruption or whatever, I don't know. But if he was to say something, that Xi Jinping looks like Winnie the Pooh or something, the next day he'd be home and in jail. And so the stakes are very high for these folks, and they know where their bread is buttered. And so I think that's why it really does matter. And it goes to the neutrality of these organizations. Obviously, there's been a lot of discussion about the WHO this year and its slow reaction, arguably because the head has, the funding is now coming largely from China since we've left it. And so that matters for the quality of international governance. And, it sort of illustrates exactly what's at stake.
Now, when you describe the position of Chinese officials in these organizations, it does remind me of secondment and the controversies over that during the Cold War. Is it any different than when the Russians were appointing people high officials that were supposedly independent, but were really seconded from the Russian ministries.
No, I don't think so. I mean, I used to work at the Iran-U.S. Claims Tribunal, which you know about, Jose, which was a dispute resolution board between Iran and the United States. The American judges would be appointed by the president. They would go over and they would act like judges. The Iranian judges could not act like judges. They never decided a single issue, procedural or anything else, in a way that was against the interests of the Iranian government. And we understand why that's true, but it means that any claimant before that tribunal was already starting 3 votes down and made the argument that much harder. So it's exactly the same. And we just have to be clear-eyed about it. We can't pretend that that's not happening. And maybe that, that requires either insisting on, arm's length behavior by the appointees, which might involve even giving up citizenship, or reducing the stakes of what these organizations do. And that's why authoritarian international law, that's why it's a concerning trend for those who are concerned with international law.
Well, and it does remind me of one of the responses in the AGIL symposium to your article, which is that international organizations are to a considerable extent enablers of what you're describing, because they don't do anything about it. They just call them independent civil servants, and it pervades them. So, for example, in the International Labor Organization, China is a longstanding member, but the premise of that organization is that you have independent labor unions, and that they actually get to vote separately from the government. I dare say that's not really what's going on in China. So the ILO is just serving as a UN blue coating of Chinese labor practices, which are dramatically at odds with what that organization is all about.
Yeah, I agree with that. At the end of the day, the United Nations system is utterly small. This goes back to the question. It's the budget. I was just looking this up for my class in international law. The UN peacekeeping budget isn't maybe twice the size of the police budget for the city of Chicago here. The overall budget for the UN is like the budget of San Francisco. It's not a lot of money, but the legitimacy and the legitimating possibilities of the organization are massive. And that's where our revisionist approach is not, dare I say it, very realistic.
So a second question is about the rule of law in BRI countries. We hear quite a bit about BRI government lawyers being trained. China is spending a great deal of money doing that, training government lawyers, training prosecutors, training law firms even to engage in this hub and spoke. What's the consequence of that? Should we be equally concerned about Chinese soft law or soft touch here? That is, it's not that it's influencing the law, it's influencing the people.
Right. So here it's happening. I'm less concerned in part because I'm also on record as arguing that China's investment in its national domestic legal system has been genuine and real. Tai-Su Zhang and I argue that Chinese courts have never been as independent or as capable as they are right now in the history of the People's Republic. And, that's consistent with building up institutions for dispute resolution for private citizens, for controlling agents. There's been a great deal of professionalization in the Chinese courts. And so they do have something to offer, I'm sure, particularly with information technology and case management, things like this. I'm sure that they are, doing as much as good work as, those of us who spend a lot of time in developing countries trying, from Western countries, trying to promote the rule of law or to try and promote legal reforms that institutionalize law. So there's kind of a technical aspect of this, which doesn't concern me that much. However, of course, what it does mean is that if there is some dissident who's criticizing, China in X or Y country in the regime, turns and wants that person extradited, or, there's channels through the network of communication which might, ultimately make a difference in particular cases. But I don't see it as the gravest of issues, I have to say. I think probably China could do net good here, as with some of the soft infrastructure in BRI.
So there's another question on the choices here. That is, we're talking a lot about Chinese influence in multilateral organizations, but other than perhaps the Shanghai Cooperation Council, do you see much evidence of authoritarian international law being pursued through regional alternatives that are sort of exceptions to carve out specific areas from general international law?
Yeah, so this is an important question because a lot of my evidence is about regions, right? Regional organizations, not just in East Asia, the Gulf Cooperation Council I mentioned. I think, ALBA in Latin America, which right now is Venezuela and Cuba, those are the only countries left. But, that's obviously an authoritarian international organization, which is providing mutual support for both countries, and was trying to extend to the other Bolivarian regimes. And so it does exist outside of East Asia. And it does lead to the question of, am I really talking about general international law or just regional? And it's certainly possible that things like the extremism and separatism norm are just going to be regional norms and don't shape international law as a whole. But on the other hand, when you combine that with China's very strategic engagement with general international law, I don't really see why norms developed at a regional level wouldn't be shifted up to the global level, with Chinese hegemony. And so I think certainly regional custom is possible, but not necessarily limited there. The other thing, there's a very interesting statement by Russia and China in 2016, a joint statement on international law, in which it emphasizes what some documents, not that particular one, call the rule of international law, not the international rule of law, but the rule of international law. What might be the difference? Well, it's a subtle difference, but it means everything. The international rule of law might be promoting rule of law values at the international legal level, things like transparency, due process, and things like this. Rule of international law emphasizes the role of the United Nations, in particular the role of the UN Security Council, as the exclusive authorizer of the use of force. And of course, that's Russia and Chinese veto. Rule of international law is a much more conservative, constraining view, which sees as its chief target, unilateral actions. And there are many UN resolutions about this, all signed by, or all voted on exclusively by authoritarian regimes, criticizing unilateral actions in defense of human rights, for example. All focused on the United States. So now that you might say, well, maybe there's something to it. Maybe we should, that ending unilateral sanctions would be a good thing. The problem is that these authoritarian regimes act unilaterally all the time, right? Mongolia, I mentioned before, whenever the Dalai Lama comes in, the Mongolians are Tibetan Buddhists, and whenever the Dalai Lama shows up, there's economic sanctions and severe saber rattling from China. So they're perfectly willing to engage in coercion, economic and otherwise, unilaterally. Nevertheless, at a rhetorical level, they've been able to get other states to sign on to the idea that only the Americans are engaged in that.
So there is a question that stems from what you have just said, which is China and Russia. So there is some literature suggesting that the joint declaration on international law between Russia and China demonstrates the rise of authoritarian international law. Can you say a few words about where you see that relationship going? And isn't it possible that the two authoritarians will conflict in their interests? They don't always vote together in the Security Council. So what's the future of China-Russia authoritarian international law?
Great, a great question. So obviously, two countries, they have a strategic relationship right now, but they fought a war in the 60s, and they have conflicts, right, as well. And so clearly at this point in human history, the Chinese regime is very well institutionalized. It is not going anywhere. China is not democratizing. The Chinese Communist Party is here to stay, and it's extremely robust. And the Russian regime I see as fairly brittle, actually. It's basically an extractive regime, one which depends quite quite effectively on, coercion and subversion. And it's clearly also the junior partner economically. The Russian economy is the size of Italy's. It's not, it's tiny compared to China. So I think China is clearly in the driver's seat, but Russia does have one important comparative advantage, which is its military capacity and ability to project force to protect its interests overseas. And so you could imagine some tensions over that, where the two are not aligned in some local conflict that arises, right? We see Russia engaged in places like Libya, now Nagorno-Karabakh. And, China, I think generally is not very interested in getting involved in local disputes. It would just like these things to go away so that people can continue making money. So they have very different approaches to the use of force. And that's an area where we might see some conflict. But China is so much bigger and more important that at the end of the day, I think it's going to be driving, it's the potential hegemon.
So it's interesting that you described the Russians as leading a brittle regime and not the Chinese, where you see it as here to stay. There are some who push back on that, and they say that given the number of languages, the teeming problems within China, it's not clear at all. I guess you disagree with that.
I disagree with that. I mean, let's see, I've been following China. I guess I graduated college in late 80s, early 90s, and I've been following it for this whole time. The entire time, there's always someone who says, oh, China's about to fall apart. It's going to break into a whole bunch of different countries. Democracy is just around the corner. And I've never believed in it. I really don't believe it now because of the institutionalized infrastructure. Things like the social credit system, things like the law, the legal institutions, and of course, the technology of repression and coercion, which is very severe. I mean, what's going on in Xinjiang? We haven't really seen anything like this, I don't know, since the Cambodia or something like that in the 70s, like really severe, and obviously there aren't the same number of deaths, but the severe re-education going on. And that, I have to say, as someone who's followed China, does surprise me a little bit. So one of the interesting things about China, when you go there, as you pointed out, it is a multi-ethnic society. If you look at the Chinese money, it's got 5 languages on it, different nationalities are represented. Chinese Communist Party has always been very good at co-opting people from the different ethnic groups into the party and serving a symbolic role, and so symbolically multi-ethnic. What we're seeing, I think, I'm not an expert on it, but it seems like a real turn to what we call Han chauvinism, where we just are not going to tolerate cultural pluralism because that itself is seen as being dangerous. So this is something we really haven't seen, certainly since the Cold War, a regime trying to take that level of control over its own society, a state trying to dominate parts of the society in such a way.
So one question is, well, is the answer to the BRI for the League of Democracies to have their own BRI? That is, can't we expand democracy's reign through foreign investment? Aren't we just being jealous? And shouldn't we just have this billion trillion Marshall Plan for the 21st century? Isn't that part of what our response should be in the West?
So, it's really easy to criticize the leaders of the American empire because, they're kind of bumbling, made some absolutely massive mistakes over the last couple of decades. But, of course, that's an idea that's been around. There actually is something called a community of democracies. It's a very small international organization that doesn't do a lot. But someone like Senator McCain, for example, was really into that idea. Maybe history would have been different if he had won in 2008. That we would have seen democracies sort of band together for this threat. It requires really strong central leadership from the hegemon. And one of the problems is, and particularly this apparent in the Trumpist era, is democracies obviously have a common interest, I believe, have a common interest in the defense of democracy, but they're also conflicting in terms of other interests, right? We have trade problems, some democracies have border problems with each other. So it's hard to keep that coalition together for the kind of real, deep work that it would take to really play much of a counterbalancing role. And here's where, back to your question about, I think it was a good question, Jose, about, is this really a sword or a shield on the authoritarian side? Maybe it's just a shield. And it's a lot easier to create a shield than to actually forge a sword, which would require common action by a lot of players with disparate interests. I think, it would be nice if democracies had done it. It may be a little late now.
Well, and I think your response just now points to a fatal flaw in democracy that is often portrayed as a virtue, which is that we have so many voices in a democracy that it is hard to have a consistent foreign policy, even within a single democracy, across administrations and even across federal agencies. So one of the strengths that I think the Chinese government has stressed is, look, we can actually have a unitary executive. You just dream about it in the West. And therefore, even if it were a good idea to do our own BRI, it's not just that we can't get a league of democracies to act together, it's that we can't consistently adopt that policy and have it carried through from a, say, Trump to a Biden administration. So isn't the problem inside democracies when it comes to foreign policy?
Right. So this gets back to the old logic of commitment. The democracies, the interlocutors with the democracy know that that government is not going to be around. And so you need some way of making that promise credible, or else, it's not worth the paper it's printed on. And of course, that's one reason, of course, why democracies prefer, like international law, and have done so much to cooperate. Yes, and even in your area of international economic law, we see that authoritarians have an alternative mechanism. Saudi Arabia, for a long time, had no bilateral investment treaties, but that didn't stop oil companies from, investing and cooperating with the Saudis, because they know that the royal family is going to be there. So credibility, a long time horizon, can be signaled in many ways. And China, obviously, in the early years of the reform era, didn't have institutions which made its promises credible. Instead, it had, people willing to take bets that the party was going to be able to do what it said, and the party sort of served as a substitute commitment mechanism. And I think that's absolutely right. And so that means, a lot of these dynamics will change depending on the proportion of the world that is authoritarian versus democratic. But it may be that even international economic law is not as important as it used to be in light of that, if we have very institutionalized, enduring autocratic regimes that are able to make convincing promises without such institutions.
So here's a question from our founder of Valley, Professor Jerry Cohen, and it goes back to the BRI, which you just mentioned. What about bilateral dispute resolution arrangements with various BRI countries? How does the project purport to settle disputes? Where? By what organizations? By what procedures? This is not WTO that we're talking about.
Right, exactly. And so, well, first of all, one thing about the Chinese regime, which is really important to keep in mind, is the fluidity of the private-public divide. So when a Chinese SOE comes and concludes a private investment contract in Pakistan, is that a matter of national, is that subject to a bilateral investment treaty? Or can that be just resolved by intergovernmental dispute resolution or intergovernmental negotiation? Because, everything is ultimately could be connected to the Chinese state. So I think it's an important question. Now, the fact is China is not sure, but it has invested in legal infrastructure, as Jerry well knows, through the International Criminal Court, branch in Xi'an, branch in Beijing, Shanghai, which are designed to develop new forms of dispute resolution, maybe new kinds of modes of dispute resolution that mix interstate and private, that mix mediation and arbitration and judicial dispute resolution. So they've invested a lot in capacity, knowing that there's going to be disputes. The agreements are not particularly transparent. We don't have a lot of the documents from BRI, because why would we? there's not much benefit. That's part of my argument. There's not much benefit from China, for China, in making these things public, because they're really working at a government to government level. And indeed, the Sri Lankan case I mentioned before, China ended up controlling the port that it built. And now it's a 99-year lease on the Hambantota port. And that was not transparent. That was, those documents were not out in the open for the Sri Lankan public to evaluate. So that's part of my argument, that it's the sort of mystery of it all that leads to this kind of hydraulic pressure away from democratic norms. But the fact is, we don't know a lot. I suspect it will be pretty good technical dispute resolution for ordinary commercial relations. And when a particular matter, whether private or public, rises to a certain level of significance, then we're going to see government to government pressure. And of course, any government negotiating with China is junior, other than the United States. Any government is weaker and smaller. And so that bilateral, rather than a multilateral structure, actually empowers China in each individual transaction.
Well, as you know, Matthew Leary, among others, has written about China's efforts to create its own versions of the London Court for Commercial Disputes and the Shanghai Commercial Court. And these would be commercial courts for private disputes, that is, for disputes among private parties that arise from the BRI, located in crucial places in China, dominated by Chinese judges and applying, presumably, a good chunk of Chinese law as related to the BRI and coming out of those contracts. Do you think that based on the fact that they're likely to be, as you call them, technocratic, a viable step forward? And if so, what businesses in Africa and in all these countries will trust Chinese judges to resolve even their commercial disputes?
So I think this gets back to my point I was making before, that the Chinese, domestic courts actually do have a good deal of autonomy in ordinary matters and a good deal of quality. Though the creation of those courts was not decided by Xi Jinping at the top. The creation of those courts was an initiative of the Supreme Court. Knowing that the BRI was coming down the road, they were saying, well, this is how the Chinese system operates. Like, what can we do to contribute to keep our institutional profile to this massive project that's going to go forward, this massive foreign policy initiative? And they cleverly came up with this idea, and they've invested real skill and quality in it. So my prediction is that it's going to have a record of really good, high quality dispute resolution once it sort of starts to resolve some cases, and it will, have a reputation as being a high quality institution, something like ICSID. The difference is that if there really is a major thing, then at the end of the day, obviously the politics are going to dominate. But is that really that different from us? I think about the Lowen case in international investment law, which was involved in, it was a NAFTA case involving billion-dollar judgments against a Canadian funeral home company, when there was a lot of pressure brought to bear on the arbitrators, and I know this from talking to them, that don't decide this one against the United States, or the whole NAFTA regime is going to collapse. So we do this too.
Oh yeah, no, I mean, it's astounding that the U.S. has faced some 18 NAFTA claims while the NAFTA was still in full operation, mostly from Canada, and has won every single one of them. I don't think that it's just because of the high skill set of the U.S. lawyers in the State Department who defended all of those successfully. It's about what would happen if one of these cases would actually go against the United States. Would the U.S. just simply walk away from the NAFTA? So there's a great deal there. Now, here's a question that comes from the former executive director of USALI, Ira Belkin, and he wants you to revisit what advice you would have to U.S. policymakers given the increased domination of China and authoritarian regimes within international organizations. And here, just the case in point is the WHO. So obviously, if you had a President Biden, he would be jumping back in. He would say, well, of course, we're going to pay our full share in the WHO. But what more, other than the obvious of not disengaging and letting China come in, would really be a powerful counter to China in the role of IOs?
Yeah, so I mean, obviously, this requires a lot of on the ground work in a lot of different IOs, right? So the answer is not just engagement, but really active engagement. I think it's incredible that so many democracies, small democracies in the Caribbean and other places, real democracies, voted with China in the Human Rights Council, vote with China in ordinary resolutions in the UN. That's, to me, just a failure of diplomacy, of old-fashioned American diplomacy at the United Nations and elsewhere. So it's sort of an obvious answer, but I don't see anything else one would do other than take this seriously. Look for areas of cooperation with China. I'm not a cold warrior here, right? That is, there are, even in the current regime, which has been obviously, much more aggressive, I think lots of areas for common good and certain global problems that cannot be solved unless there's engagement with China. So I think that, it's not just us versus them. Obviously, climate change cannot be solved unless America and China are on board. And that would be my priority because I don't think any other problem matters relative to that. So, that's what I would do. But it really is kind of, the answer is more in diplomacy than in law.
So I guess that raises the perennial issue that, of course, some of the biggest global problems require the US and China to work together. Climate change is one, nuclear proliferation is certainly another, and lots of other environmental issues, including the possibility of shooting war throughout the South China Sea disputes. If the US and China can't deal together on these issues, we could be in both very serious situations in terms of World War III, but also, as you say, climate change. And yet, we face, as you described it, potential crimes against humanity, and I would say even genocide with respect to Chinese treatment of Muslims in particular. When I say genocide, I'm talking about latest revelations of preventing births in a group. The Genocide Convention doesn't say you have to kill thousands of people to be guilty of genocide. If you intend to do so and you prevent births in a group with the intent of doing what is eliminating a particular culture, religious group, etc., you are potentially guilty of genocide. So we're back to a fundamental question about how do you deal with a modern Holocaust? And isn't that a real problem? But how does the West respond to that and still work with China on these other issues? We didn't have to work with the Nazis to figure out climate change.
Yeah. Look, genocide is obviously, like many areas of international law, one where normative articulation is far ahead of institutional structures for enforcement. And, the convention obviously has some dispute resolution at the ICJ. A country like the Gambia brought Myanmar to the ICJ. I think, although China, I think, has reserved Article 9 of the Genocide Convention. You could imagine a country making a claim and bringing a case to the ICJ saying that reservation is severable, or is invalid, and China is thus a party to the Genocide Convention, including Article 9. In international law, this is kind of the Scandinavian approach to objections to reservations, and bring a claim. And of course, China would go crazy and stop all investment to that country. But it could be done. But this is the problem. It's essentially in the domestic jurisdiction, and I think it's actually really shameful that co-ethnics, co-religionists are turning a blind eye to this, while they focus on other conflicts which are just much smaller maybe in scale, but don't have the powerful advocates.
So I take it your answer is not the answer is not decoupling.
Not from my point of view. I don't think it's possible. Look, if every member of the OIC, all of which are in the Belt and Road, or the vast majority of which are in the Belt and Road, are going to continue cooperating with China while China tries to end an entire religion, their religion, who are we to decouple?
So we have a more philosophical question, which is what you describe is because of the Westphalian system, that international law is totally dependent on the will of states, and the Lotus Principle in particular. Can you imagine a future international law system that is not based on the structure of the nation state, and therefore not subject to either hegemonic international law or authoritarian international law as you describe it?
Yeah, so that's very interesting. That's a big question. I'm kind of coming from a traditional Westphalian point of view. It's just how I was educated in international law, and I've always thought that there's
a political scientist isn't a Westphalian ultimately.
Well, yeah, there obviously are these other, cosmopolitans out there who think that the purpose is individuals, and so international law should have that approach. I tend to think, I'm a big fan of Professor Brad Roth. I don't know if you know his work, but big defender of the morality of sovereignty, that there's no way the world would ever converge on a set of cosmopolitan ideals. It's just not going to happen. So we're going to have pluralism, and so we need mechanisms to work across that. So a very thin kind of view is where I start. Now, all that said, there's some very interesting stuff going on with the enforcement of international law. And actually, in the journal, the American Journal of International Law, the same issue in which my article was published, Jay Butler has a piece on corporate enforcers of international law, private sector actors who internalize, whether for selfish reasons or not, the values of international law and actually go out and enforce it. So you can imagine, let's just take the case of Xinjiang. If we had a massive boycott of, I don't know exactly what it would be. This is the problem. I mean, how do you boycott Chinese products? I mean, we'd have to now end the Zoom call immediately. And so, it's pretty tough and getting tougher. But that kind of mechanism is a real one. And I also firmly believe, as I said before, that people all over the world do want good governance and are going to continue to demand it. So maybe, the promotion of international law, soft international law, whatever you want to call it, that's more citizen-centered would be a very good thing, because it would shape the way that states react to these world and shape really, realism is a bad term because it's such a high level of abstraction. What is the state's interest, right? That's exactly what we fight about all the time in democratic politics. But, that kind of bottom-up movement can help shape state interest, shape political actors' interest in their policies, and thus sort of indirectly shape the behavior of other states which might not be inclined to follow the cosmopolitan rules. So that's kind of how I see it.
So you just mentioned the unmentionable, which is Zoom, and the fact that we're relying on Zoom and increasingly reliant on remote and data and the web. And I think that will probably not change even after the COVID era. And that raises the question of our role as academics and scholars. Will there be a day, if authoritarian international law has its way, paired with Chinese products, for instance, and the place where servers are located, where the conversation we just had on crimes against humanity and genocide will not be possible through Zoom or perhaps any other remote device? That is, what's the consequence on academic discourse in a world of authoritarian international law?
So first of all, we're in the United States, so we're lucky because we do have alternative providers of these things. And U.S. government uses WebEx, I think, and Microsoft's got something. So, there are going to be such alternatives for us, I believe. But it's a very important point that our great leaders running our country focus on this precisely. And you're starting to see this with the discussion, the focus on Huawei and the cyber treaty I mentioned before. So there is some concern, but it really is going to require active assurance that such platforms remain available. Already, the law on the Special Administrative Region of Hong Kong criminalizes behavior everywhere in the world, potentially that takes place in a Zoom call. I could violate it right now. So, that's concerning. Now,
does it make and obviously that law, as I understand it, does not just apply to Chinese citizens operating abroad.
Anybody.
It operates to you and me.
Yeah, so I'm maybe Professor Cohen and I, first met in Taiwan. And so I'm sure, we could have a discussion about Taiwan, which would be anathema, though not yet illegal for the Chinese government. On Hong Kong, I tend to be a sovereigntist. I believe that the handover occurred and now Hong Kong is part of China. So it's not automatically a part of, it's not really an international legal matter necessarily what goes on in Hong Kong. But the extraterritorial jurisdiction is a significant matter because it affects our classes at universities. If I have a Chinese national in my class and I start talking about, if I took a view of Hong Kong's independence, which I don't happen to hold, well, then, that person in my Zoom class could be punished potentially. And I certainly could be, indicted when next time I go to Hong Kong. So that's real. And this is, I think, just like so many things with the rise of China, start to feel the river by crossing the stones. It's an experiment. Let's see how other states react. If we get away with it here, soon we'll do the same with Taiwan. And if we get away with it there, then soon we'll do the same with other core interests.
Well, given the extraterritorial law and your own article on authoritarian international law and our own little conversation that we've just had, do you feel like you're ready to go next time when Beijing invites you to a conference? And that's a serious question. That is, are we censoring ourselves when we do this? Are we making the extraterritorial application of law more effective when we're afraid to go to that country now or to Hong Kong?
Well, that's a great question. And I have many friends on the call who maybe are much more outspoken than me. And many of the people in the Q&A are much more outspoken than me. And, at some point, I think, your conscience says, well, I'd rather say what I think than go see my friends in Beijing or Hong Kong. I mean, that could come to that point. For me, myself, I've taught in China. I love it. I go. And I haven't been actually for some time. So, but I think I will go back. I don't really have a big fear of it. But you never know. These Canadian diplomats were arrested when Canada arrested the Huawei executive for extradition in the United States. You don't want to be a pawn. You don't want to be a hostage because that would be a very unpleasant experience. But at some point, there are a lot of other countries to go to for someone like me, and I don't need to go there. I would miss it, but I'd be willing to give that up. I face that in other countries too, by the way, in Thailand.
This may be the last question. So we have one about the reactions to the Philippines v. China ruling by other countries in the region, and whether that backlash, for instance, may cause some disturbance in the progression of the history you're describing. And in today's New York Times, there was further evidence that perhaps China is, despite the fact that everybody hates the US, especially on its reaction to COVID, it's not necessarily much better with respect to national views and public views of China with respect to COVID and other issues, including law of the sea questions. So that backlash is there. It's not clear that China is winning hearts and minds. So how does that play into authoritarian international law?
Oh, that's a great question. And look, I think the authoritarian international law stuff is going to continue regardless. But China has clearly made some mistakes, right? And one theory is that rising power, you're going to announce, hey, here we are in the world. We're going to start taking our interests seriously. Maybe they did that 5 years too early. Maybe that Xi Jinping was a little impatient here, because we do see backlash. I mentioned this election in Sri Lanka. There was also one in the Maldives around the same time where China had backed this totally corrupt candidate. And you know what? He lost. And so I think that's the virtue of democracy, is that these ties become transparent, and you get too close, you're going to be burned. And so that's, to me, why it's such an important moral matter to preserve democracy. I think that and it gets back to your criticism that you started with about the binary. I don't think we can all find nice dictatorships. It would be wonderful to be born in Singapore. But for every Singapore, there's a Xinjiang or a Pol Pot's Cambodia. And the fact is, the ability to express ourselves in this way and to disagree is incredibly precious, and we all take it for granted. Most Americans certainly take it for granted. So to me, coming up with ways of defending that democratic space is really important, while recognizing that, you know, it isn't for everyone. So that's kind of where I am normatively, and I struggle with exactly what that means institutionally for international law. I have to come up with an answer before I finish my book manuscript.
Well, thank you. This has been a wide-ranging and candid, I think, discussion, which I hope all of us can appreciate. If you were live in our conference room, you would get massive applause, even though there are likely to be folks who disagree with at least some of what you say. But thank you for participating, and we look forward to your next article and, of course, the book version of your current one. Thanks very much, Professor Ginsburg.
Thanks to everyone for coming, and thanks for the opportunity.